Social justice means applying the law equally to all people, but in practice, that doesn't always happen. I'm John Gonzalez. I'm here with my law partner, Jack DeRora. We practice law, we seek social justice. On this show, we reveal the conflict between the two.
You know, for a while, it was just us in the office over a cup of coffee talking about the news of the day. With social justice issues dominating our culture, our focus became how do we, as lawyers, make a difference?
And now it's not just us. Today we have Josh Koskoff, the lawyer for the families of the Sandy Hook victims, who took Remington, the company that manufactured and marketed the AR-15 style rifle used to murder 20 children and 6 adults. Took them on in court. Welcome, Josh.
Thank you. It's good to be here.
Jack, one of my early jobs in law when I was with a bigger firm was a part of the Chrysler Corporation defense team. I think I sat 15th chair, just inside the courtroom doors. But the big fight in those cases, these were the Jeep rollover cases, was to keep information away from the plaintiffs in the case. And just briefly, what it was a group of engineers decided to see if the Jeeps had a propensity to roll over more than other vehicles. So they went out in the field and drove cars around in a circle to see at what speed they would start to tip. And plaintiffs' lawyers really wanted the results of those studies. Now, it wasn't very scientific, but we fought harder to keep that out of the plaintiff's bar than anything else. We would settle cases to keep that information. It's the kind of the nature of the game. And the reason I bring that up is I was reading some stuff about Josh's case with Remington, and it seemed like it settled right after you were able to start some discovery. And I bet Remington didn't want that to happen.
Oh, yeah, of course. And that your story brings to mind what happened with tobacco litigation. So many cases were dismissed. Plaintiffs were struggling to get to the information that the cigarette companies had. For whatever reasons, courts were granting the tobacco companies relief. But finally, 1 or 2 courts said, yeah, that's discoverable. And then the dams broke open.
Sure. And the other way companies keep that information, away from other litigants is, through protective orders, confidentiality agreements, things like that. Josh, you filed a lawsuit against Remington for the victims back in 2014 and then resolved it 8 years later. Is that my understanding?
That is correct. Yeah, Gonzo, that's right.
That's amazing to me. We've got a lot of questions for you, but I'm always interested in kind of the inside baseball story. How does a firm like yours, you in a big multi-lawyer practice or a smaller firm, and how does it take on a case that lasts that many years?
Well, I think it starts with the culture of the firm. Are you a firm that plays it safe, handles only cases that you're going to win or settle, or whether you're a firm who prioritizes, in addition to keeping the lights on, doing something challenging but righteous for worthy people. And I really would say I'd like to take credit for it, but it really is the culture of the firm that I inherited from my grandfather and my dad.
How big of a firm did you have at that time, or do you have now, if it hasn't changed?
Yeah, I mean, we're about, that's a great question. If you had asked how many people work at my firm, I would give you my grandfather's answer, which was about 50%. We have about 20 lawyers, and we're not at 50% anymore. We're about 99%.
How did your firm pick up this client? How did the victims come to you?
Yeah, the way I get all my cases, by getting a ride to the airport and having the driver tell me that he has a friend who needs help. It actually was very unusual. I say that tongue in cheek because you would think it would be something a little more structured or effortful. But basically, As you guys know, as lawyers, when you strike up a conversation with anybody in your lives, whether they're driving you somewhere, you're in a car with somebody, or at a coffee store, and you tell them you're a lawyer, you really have no idea what's coming next. And in this case, it was that the driver's friend lost a daughter in the Sandy Hook shooting, and that his friend was really having a hard time. So I offered to help, and wasn't thinking of a lawsuit then. This is about a week after the shooting. So,
Oh boy.
also, as doing the type of law that we do, imagine I hope a mass shooting hasn't hit you yet, and never will. But if it happens within, 10, 15 miles of where your office is, it's just instinctive to want to help, right, the families, or do anything you can. So I wanted to help, but really it came at me very much by happenstance.
One thing that I really latched on to in reading the complaint that you filed was that you had access to Department of Defense materials, which delved into the science behind the AR-15 and all the Army safety protocols. So first thing is, how hard was it to get those Department of Defense documents?
It was about as hard as Googling them. I mean, I don't want to be too glib, and I have to give credit to my colleague, Katie Messner-Hage, who dug that up, but she did find it online. A lot of the material, guys, what was unusual about this case, and I was very much listening to your kibitzing earlier about how the defense playbook is to give the plaintiffs as little as they can of relevant information and to dump as much irrelevant information on you as they possibly can, and that certainly came into play later. But the truth is, there was so much information now that is sort of hiding in plain sight, and you just have to have a reason to look at and research what's online and put a story together. So whereas before, I think as plaintiffs lawyers, we were much more dependent on the other side. Here, there's just so much available to us before we file suit. And the challenging part is, of course, separating the wheat from the chaff and putting the pieces together like a puzzle so that you can tell a compelling story. And I felt very confident, at least up until the time by the time we filed our lawsuit, I felt very confident in its chances.
Before, I want to put the importance of that defense document into perspective, but to do so, I need for you, please, to explain that legislation that precludes gun manufacturers from being sued in just about all situations, but the exception that exists that gave you a foothold against Remington. And I'm going to ask you to, keep it simple for dummies.
Yeah, well, good, because I'm a dummy that needed it to be pretty simple. And I'd never heard of this piece of legislation, sometimes referred to as an immunity for the gun industry, called the Protection of Lawful Commerce in Arms Act. It was effectively a piece of legislation written and sponsored by the NRA and passed in 2005 because the industry was afraid that it couldn't withstand being accountable for all its conduct, or that it would basically go bankrupt. We're talking about a very small industry. And so if you think about it as Protection of Lawful Commerce in Arms Act, this has protections against what we would call negligence lawsuits, common law torts lawsuits, but it has carve-outs. And some of the carve-outs, or the exceptions rather, to the immunity are really only as thick as the paper they're printed on. But one exception in particular in which you can find some daylight is if the conduct violates a state statute applicable to the sale or marketing of firearms, you can still sue a firearms company. So put another way, Congress was willing to extend some pretty healthy protections for the gun industry, but Congress was not willing to immunize the gun industry for conduct that violated a state or federal statute applicable to sale or marketing.
So that exception, in simple terms, was? It's negligent entrustment, right?
Well, okay, so you're on the Josh Koskoff theory, which I thought was a stone cold winner, because getting back to your comment, the Department of Defense document, if you think about the, I don't know, the New England Journal of Medicine being an authority on medicine, or, the NHTSA being authority on safety or what have you, there's no greater authority on the lethality of weapons than the United States military. And so they issued a comprehensive study when they were thinking about adopting the AR-15 as the weapon, as to whether it really was worth the hundreds of millions of dollars of taxpayer money to protect and serve our troops abroad. And they decided it was, and that Department of Defense manual lists how effective it is at killing. The other thing it did for, I think, you and for me as trial lawyers is it caused me to say, hold on a second, how is this weapon, which is designed for the military and so needed by our troops, and is needed especially because of its degree of lethality, and how is it that the military takes such care of this and you can't get your hands on it as a soldier until you put in 100 hours? You've got to watch it at all times. And you could be court-martialed for leaving it somewhere you're not supposed to. How could that same weapon be sold to an 18-year-old in Texas or Connecticut, for that matter? And it seemed to me that is the ultimate negligent entrustment. We were not saying that the weapon was defective, right? We're saying it was introduced to the wrong environment and to the wrong people, namely civilians, and more specifically, adolescents or young men between 18 and 25. Struck me as a good negligent entrustment claim, which is an exception to the immunity we're just talking about for your listeners. The Supreme Court of Connecticut felt otherwise. They shot down the Koskoff theory. But they did find that we had stated a claim for violating a state statute that was applicable to the sale and marketing of that firearm, and namely Connecticut's unfair trade practices statute, or consumer protection statute.
Now, would you, at the time, however your court was, made up politically, was it a conservative court? Was it a more of a liberal court, consumer friendly?
I mean, I would say that judging on the curve of the United States of America, it was on the more liberal or progressive side. Connecticut is a blue state. It's a solidly blue state. But I mean, as we all know, while that may be a barometer in general of an outcome, you can never really count on that alone as determining an outcome. I will say that, Connecticut is an interesting state because it's the home of some of America's most legendary gun makers, like Remington. And it does have, and yet, there are the communities that are very much all about, sensible gun laws.
It struck me as interesting that the United States Supreme Court didn't take the case. And I was trying to think back as to, and I'm a little more politically minded. My wife's in politics here in Ohio, and I run for office. But so I'm always looking at the political makeup of the decision makers. But I was trying to think of who was on the court when the court would have refused to take this case, because you think about the court now and you think, oh my, why wouldn't they have just taken it on the shadow docket and reversed everything? Yeah. But the only difference would be Ruth Bader Ginsburg was still on the court at that time, I think. Did you handle it all the way through the jurisdictional motions to the Supreme Court? Mm-hmm. Yeah.
Well, it sounds like you're aware, guys, that we did, not surprisingly, they did petition for cert to the Supreme Court. We had to come to grips with my own limitations, not having had to defend a petition for cert in my life, or make one for that matter. And I quickly learned that there's a whole cottage or niche industry of lawyers whose job it is to say either nothing to see here or you have to take this case because the fate of humanity rises on it.
And so you got one of them.
I got wonderful help from Don Verrilli, who I'm sure you guys know if you know anything about. I mean, I didn't particularly know him at the time, but he was Obama's Solicitor General, and he put together a fabulous draft petition for cert. Which, I mean, I say draft. He wrote it, and I was very gracious in working together to file what I thought was a phenomenally articulated reason why the Supreme Court had no business taking this state court, case in medias res, or as an interlocutory matter.
Nice. So at that point, the posture of the case was it was going to go back to the trial court. And then was there another motion to dismiss at that point when you came back? What happened with that?
That's a great question. I mean, of course, that it belies your legal chops there. I thought, I mean, how many motions to dismiss can you actually beat in one case? I didn't know you had to beat more than one. But there's no penalty for them trying that, multiple times, and that's one of the problems we're facing today is with there being no penalty for people trying things that might seem frivolous. But yeah, they challenged our case a second time. Now I did amend the complaint because they did bounce the negligent entrustment, and I did tidy things up a little bit. And I guess that's as much as I will state on the record. but they did challenge it, and and basically I said, Judge, this is a first for me. The the Supreme Court of Connecticut has already greenlit this lawsuit. The United States Supreme Court has denied cert, and they're still challenging the grounds for our lawsuit. I said, this has never happened before. Mm-hmm. So she basically, to my recollection, she may have ruled from the bench or either that or the day after.
I am always interested in not just the technical legal aspects, but the human side of all of this. You had a number of families of these victims. I'm assuming you met with all of them and talked to these people. Can you describe how that was? And I'll just tell you, I've done a number of wrongful death lawsuits where I've met with families that have lost loved ones. Got to be one of the toughest parts of a job to sit and listen to them, and then kind of put on your own shoulders their hope and trust in you to bring some type of justice. How was it with that many families of victims?
Well, I think it was at a level that I had never experienced before of just sheer pain and grief. And there was a level of it, Gonzo, there's like shock, just shock. Like people walking around, going through the motions of life, but just in the state of perpetual grief. Like you, I cut my teeth on wrongful death. I wouldn't say cut my teeth. I probably cut my teeth on not wrongful death cases. But once I became somewhat competent, I started handling more serious cases. And so, the discipline or the skills you develop to speak to somebody in the aftermath of shattering loss certainly are helpful. And they do take a lot out of you anyway, but to do it in this way, and also, I mean, there was just something so relatable as parents of kids around that age that was really, really particularly gutting. Mm-hmm. And, there were many times where I just dealt with it by crying. Not in front of my clients. Sure. I had to hold it in.
No, well,
sometimes it was hard.
I remember when this happened, our kids were in high school and our youngest was in middle school. And we just, as soon as they got home, we're just hugging them.
Yeah.
Because, it's that real to any parent. Not you just don't have to be a parent, obviously, to understand it. But it is, it's so emotional. And then you have 8 years of litigation where you have a lot of bad news that you have to tell these folks. And right. Did you have people, we don't have to get into specifics, that were like, look, I can't do this anymore? Or were they pretty much in for the long haul with you?
I mean, if anybody was getting weak knees, it was probably me. And I say that maybe, with all humility, because but anytime that I would feel like, oh my, another hurdle in front of us, I would just really turn to the families or think about them. Really, I wouldn't put pressure on them, but I would just think about how are they getting through life. How are they going to how are they raising their other children? How are they going to work and keeping a family fed? How do they even get out of bed? It just I just found such strength in them, and it was really hard to be. I mean, basically, I was like, well, if they can move on, get through the day, I can handle this weekend case.
Did you have all of the victims' families, or were there some people that were not interested in pursuing, any type of legal action?
The latter. I mean, we had all the families that brought suit, but you kind of sort of on a good. You're in the right direction. Like in a situation like this, especially if you think back then, we're going off into a very black hole. There's no cases quite so on point. The law is really, really challenging. We know it's a case that's going to draw a lot of haters out of the forests, sometimes literally, and that we just didn't know what we were heading into, and so I had to be very transparent with them that there was safety in numbers, but that the odds were stacked against us. That I believed in the case, but that the law was incredibly challenging and we were heading into new territory. And I can't guarantee, not only could I not guarantee an outcome, I said, it's a very, very long, hard battle ahead. And it may not be, I want to say it may not be for you. I didn't want to drag them through something that only brought pain, and they had to be ready. And some families just understandably, 2 years, statute of limitations is not a lot of time to get over your loss and to think about something as effortful as this.
We've talked to lawyers that have handled kind of these career cases, and one thing is the internal workings of the firm and all of the expenses that the firm is going through in light of a lot of defeats. If you can say, internally, was your firm on board again for the long haul, no matter what the buildup of the costs? Because I got to imagine there was a lot of expenses being incurred as you went down the road.
There is, but yes, it's another insightful question and relevant to the practice of law. Again, harkening back to our culture, there is this sort of commitment to taking to sticking your neck out and taking a chance on a case that's challenging as long as it's righteous and you're on the right side, and potentially very expensive. Because so much of the case was built around motions and filings and arguments and briefs and all of that stuff, it wasn't so much money out the door for the first few years. It was time, lots of it. But it's just, it has the same collective effect. And I was very fortunate that the firm is set up the way it is very supportive and collaborative. If there was pushback, people had the decency not to tell me, because it wouldn't have gone over well. But that's the way our firm is. Even though it's no longer all family like it once was, we have sort of a family way of looking at things.
I have friends that love their guns, and I could imagine them showing up on your doorstep to voice their displeasure with a lawsuit against the beloved company. And I say that, a little bit tongue in cheek here, but I'm wondering, did you have those?
It's all tongue in cheek.
Were there threats? Was there concern for either your safety or your clients at the time when you were bringing this action?
Well, the only anxiety I had was really for the families being further besieged by the public. I mean, we're talking about also, and I know we're going to get into Alex Jones. We're talking about in the aftermath of the shooting, this other thing developing. So I was a little bit worried, but I thought, there a couple of things. One is I'm a realistic person, so whenever I think I'm being unduly paranoid, like about a shark attack or something, I'm realizing that I should be more worried about the skin cancer I'm getting. So the truth is, there have been a lot of people who have stuck their neck out against in brought cases that implicate the gun industry long before I did, and more outspoken advocates. And in reality, I just took stock in the fact that this is not likely, and to sort of put it at bay. And in a way, if you're not getting threats about doing something that you know is the right thing to do, then you might be doing something wrong. So having said that, yes, I got way more threats from the gun loving public than I did when we sued Alex Jones, who almost nobody likes.
So you had Remington as your major defendant. Were there other defendants? Because I know, at least from reading the Uvalde lawsuit, you also sued the manufacturers of the video games.
Yeah, that's right.
Was there any of that in the Remington case?
Well, that really came out of the Remington case. You guys wouldn't believe the relationship between the American gun industry and I can speak to Call of Duty in particular, Activision's flagship. It's a juggernaut of a moneymaker, Call of Duty. And we had in discovery, we got documents that showed a direct product placement of the effectively the Bushmaster brand at the time was coming out with something called an ACR. And this was in 2009 and 2000 with a follow-up agreement in 2011. So restating this, basically there was a quid pro quo relationship between Activision and Remington that preceded the Sandy Hook case. And I knew from having some knowledge about Call of Duty and the engine of that game, I knew exactly where the Sandy Hook shooter, got apprised of that weapon, and also about how to use it. He used tactics that he clearly learned from the game. The kid was a shut-in who played the Modern Warfare version that this Bushmaster weapon was featured in.
Is that what brought you in the Uvalde lawsuit to bring Call of Duty in? And what is it? Was it Meta?
Absolutely.
Yeah.
I am a convert. I mean, look, I would, if you asked me 10 years ago whether a video game company or any media bears responsibility, I would have said absolutely not. I would have looked at you like you had three heads. But I am now 180 degrees in the opposite direction, at least for this particular, I would call it, it's part a game, but it's more like a training simulator as features of a game. But it has been associated with every mass shooting that you guys have heard of, especially school shootings.
Let me stop you right there. Hold on. When you say associated with every mass shooting, tell me exactly what you mean. That's powerful language.
It is. And you guys should probably readily acknowledge that a lot of the work in civil litigation is trying to tease out the difference between correlation and causation, right? And the causation elements of these cases are the hardest elements because you're talking about an intervening criminal act.
Sure.
So it's always going to be a challenge. But if you go back to even before the Sandy Hook case, there was the Norway shooter who really ushered in the modern era of mass shootings, killing truly innocent people, racking up a lot of a kill count, using it, in that case wasn't an AR-15, but close. And when he was arrested, he said he learned how to, he credited Call of Duty for helping him learn about the weapon and how to use it. In Sandy Hook, again, I wasn't there yet because I, again, would have thought anything that didn't focus on the gun industry and the marketing of the gun industry was a gift to the gun industry, so to speak. But they really don't operate in a vacuum in today's environment. There's always been a gun industry, but we haven't always had these mass shootings. So in Sandy Hook, when I saw this relationship and I saw of the 40 brands of AR-15s that were on the market, this kid used the only brand featured in Call of Duty. That kind of had me scratch my head. Like I thought, that's bad.
Right.
There are people at Remington who didn't like that deal because as one person put it, who I deposed, that game was going to show kids how to use their weapons to kill, and that wasn't appropriate. So I think promoting these weapons through Call of Duty, which is as effective as a flight simulator in my view, is to, air pilots, is effective to habituating all the both the conscious and subconscious, act of killing two kids knowingly is wrong. And it's not just wrong, but it is the X factor. That and social media is the X factor that distinguishes when I was growing up from today.
I see
We
your.
always had AR-15s.
I see that recently you were back in court on this in the action against Call of Duty and Meta, and they were arguing First Amendment rights.
Yeah.
Is that just going to be another long, drawn-out battle?
Definitely.
Yeah.
That's the only
where
kind
are
we
you?
have. Well, we had arguments on the motions they have an anti-slap motion, but that's one type of special motion to dismiss, as you guys know, and then there's actually activism just filed an anti-slap, and then Meta has filed an anti-slap and a demurrer, which in my state you'd call it a motion to strike. Some states called a motion to dismiss, but same difference. So that's where we are. And we've expected these. Obviously, you have to go into these cases with eyes wide open. You have to do your homework and know what to expect so you can advise your clients, give them a timeline, and also be ready. And we certainly expected these types of motions to that attack the complaint and our right to move forward into discovery. As you said, I mean, they're going to guard discovery with their life. It's
Sure.
really hard to get into the dungeon of these companies.
Do you feel anything about Remington going bankrupt? Is it a vindication of any sorts, or is it, just a non-event as far as just what you've done for your clients and the help you've given them?
Yeah, first of all, it's not related to our lawsuit. So I was convinced it was, but it isn't. I think what it really stands for a broader proposition, which is that if you throw out all other goals in business, treating your customers well, making good, solid, well-made products, treating the people who have served you and dedicated their lives to working for you. If you treat people well, good things will come. But if you turn around your model and make it all about profit, it's not going to work out. Like, greed kills people, but it also kills businesses. And this private equity firm that bought Remington, which, by the way, also bought Chrysler at one point, succeeded in taking a company that had been around for almost 200 years, I would say, and grinding it into the ground. Of course, they did that by firing all the older employees, by consolidating operations, by having stuff made in China. That's what you get. Now, they probably made out because they squeezed the money. That's what private equity does. Yeah. That's a whole other part of this case that was surprising. It is so disparate from the narrative of the hardworking artisan that once upon a time worked at the Remington and Sons of the world.
I'm a big opponent or a big voice for gun violence and the proliferation of guns, et cetera, and just how crazy courts pay fealty to the Second Amendment without any regard for the consequence of their actions. So I'd like you, if you can do it in a snapshot, talk about all those things you argued, I guess it was before the Supreme Court of Connecticut, regarding what the Army requires for its soldiers in terms of training, safety, et cetera, in comparison to what Remington does, just selling those very dangerous weapons to anybody, and make the comparison for how you pled your case.
Well, yeah, I mean, again, this was, I thought, the stronger argument at the time, which was, now I had to learn about the military, and I'll say that one thing that was very was like an inflection point for me is that I asked somebody who was a paralegal in my firm who had been in the military. I said to him, Andrew, did you use an AR-15, or in the military they call them M16s? Did you use one, or probably M4, but same difference? Did you use one? And he said, oh yeah, but there was such strict oversight that if he showered and he had his rifle in his room, he would shower with the shower curtain open, keeping eyes on it at all time. Obviously, the military, at least initially, and when they are training, is very, very rigid about how they're going to deploy an AR-15 on its base. They're rigid about if they get wind of mental impairment of a soldier, they are not going to entrust this weapon, which requires the strictest of competence and responsibility, on anyone showing any mental or physical impairment, for that matter. And until they earn their stripes. These weapons are locked up in the barracks at military bases. As I said, if one is left unaccounted for, the soldier can be court-martialed, and they can have their service rifle taken away because they're always under oversight by somebody above them, right? That is not how any of us live in our communities, right? Where nobody's hanging over our shoulders to take our guns. Nobody is even there when the 18-year-old walks into the store. There's no typically, oftentimes there's no parent or mentor around to make that decision or to help stop the kid. And what's alarming is it is especially the type of kids that have no mentors or parental figures in their lives that are more prone to go out and pick one of these up for purposes of grieving their terrible adolescence. And that strike me as just why do they? It's a big chunk though. They're selling a product and they're legally selling something. So you run up against the argument that the law has allowed the sale of these weapons. So how can you say en masse that it is a negligent entrustment when those responsible for carrying out public policy and enacting laws have said that it's legal, right? So you guys can see that the difficulty in pushing against that weight. And so what I sort of did was try to pivot more to a more specific claim that it really had to do with entrusting minors, or those who were recently minors. But effectively, the Supreme Court of Connecticut found that under the same facts, that what we were really saying was that they shouldn't be pushing these guns on minors through marketing. And that was a separate claim, all tied up into the big set of facts, but a discrete claim in the case. So we got to the right, I guess, result, if by a slightly different road than I thought it was going to get there.
And the ultimate result was that at some point, Remington caved and didn't go to trial.
Yeah, it's interesting. And also your listeners should know that, because you might have an idea of Remington, sort of the iconic American gun company. This was not that. This was a collection of gun companies that had been rolled up by this private equity firm called Cerberus in Midtown Manhattan. And Cerberus was trying to build $1 billion company and a $1 billion gun company. And they largely almost got there by cornering the market on AR-15s, which is the highest margin firearm. So this was an intentional effort by very smart people who knew how to make money. And what ended up happening is the bankruptcies of Remington, we had to go through 2 different bankruptcy proceedings. Ultimately, it was effectively put into what we would call a receivership. Then we got into the whole bankruptcy side of things and more counsel, more need for us to get some people who knew their way around bankruptcy. But the upshot is that we were able to obtain a settlement with each of the insurers in the insurance tower, who were represented by very smart coverage counsel. And so we had to effectively, if you imagine a tower with several floors on it, we had to prove to each floor that we were going to win the case, or at least, and that their exposure, of course, was astronomical.
Mm. Yeah, I got to imagine they really increased their market share when they started selling these guns to civilians. Yeah, can you imagine being the people that made that initial decision that here's what we ought to do to sell more guns, and then seeing your gun used in such tragedies? Josh, I got to meet one of the inventors of the trampoline when we were doing some products liability work in my old firm, and he was beside himself with all the injuries and mostly, like quadriplegics and stuff like. He just, you could see that he felt so bad that he had any role in that. I wonder if anybody at Remington or this company has any remorse for their product doing what it's doing, continuing to this day, but maybe we'll never know.
Yeah, I did sense it's a great, and it's almost a very moving thing, isn't it, when you can see somebody come to a realization about maybe something that they could have, that they had a role in, that they had no intention of causing. I did get a little bit of that from some of the rank and file in the depositions. And I got a lot of the other side of the coin, which is cognitive dissonance. That thing I'm part of has nothing to do with these killings. It's something else. I make a lawful product.
Sure.
Second Amendment this, Second Amendment that. So you get all sides of humanity.
Well, that leads us to some of the worst sides of humanity, the people that will actually suggest that it never happened.
Hey, we're running out of time, so what we'd like to do is bring back Josh for a second episode. But before we sign off, Gonzo, I'm thinking we should have a new segment in the show, and maybe we would call it "How Stupid Is That?" What do you think?
Do you think you have any thing to talk about in that regard?
Well, I have a plethora of things to talk about, but here's the first one. Okay, I'm going to quiz you. You ready? What do all these events have in common? Tobacco companies hiding facts about the risks associated with smoking. Oil companies publishing disinformation on climate change. The Enron financial scandal, the Great Recession and the mortgage meltdown, the British Petroleum oil spill in 2010, and DuPont polluting the groundwater in West Virginia. What do they all have in common?
Money?
Well, money is certainly an important part of it. But what they all have in common is that all of those activities were either guided by federal law and the laws weren't obeyed, or the federal laws weren't strict enough. You with me?
Certainly. They're all very highly regulated industries.
Well, one would think, but
Right.
in some cases, I think perhaps the regulation wasn't significant enough. But in any case, that brings me to how stupid is this? And I'm listening to a podcast, I think it was The Daily Show a few weeks back, which is, or no, just The Daily from the New York Times. And they were talking about how a couple tech billionaires, Peter Thiel and Mark Anderson, came up with this idea of freedom cities. Now, this isn't something we're going to see tomorrow, but it's something they would like. So they would like to see large plots of land somewhere in the Southwest be exempt from all federal statutes, environmental, safety, financial, you name it, so that they would have unbridled freedom to pursue economic growth and economic progress. And I'm thinking, what could possibly go wrong with that idea? And so that's my how stupid is that idea for the day.
You know what's insane about that is it's impossible to do. Because if you got rid of all the regulations that are in place now by the government, still you have to have some rules, right? Because when two people live by each other, there's got to be some rules. And so what these people are going to do is create a city where they're making their own regulations. There's still going to be rules and regulations. So I agree with you. Very, very ridiculous.
Our thanks to WOSU and our sound engineer, Dalton Jones. If you like what you've heard, tell a friend. We want this to be more than just about us. We want it to be about all of us. We'll be back with another episode with Josh Koskoff, and we're going to talk about Alex Jones. Until then, so long.